Hi everyone, welcome to Lecture 18. This is the first part of Lecture 18 when we're going to start to talk about the Atkins decision. This is a really important piece of legislation that pertains to individuals with intellectual disabilities. So we're going to talk a little bit about the history of it and in the second part some recent developments in the Atkins decision. So before we get started, I think it's important to kind of have a background on the death penalty in general and specifically what states do and do not allow, because the Atkins is a federal, is a federal court decision. So in states where it's not allowed, the death penalty altogether doesn't necessarily pertain. So this website here, okay, explains and shows states with and without the death penalty. So in red, these are states with the death penalty. So this is where especially the Atkins case specifically pertains. And then the blues, different shades of blue, the light blue is states without, and the dark blue are states where the governor has imposed a moratorium as they're continuing to figure out what specifically they want to do. So this website here in general, this Death Penalty Information Center, is one of your primary sources for this topic, in addition to a couple articles. So make sure you read those articles and then click around here to get some more information that you guys can use for your discussion posts and those types of things, and just to increase your knowledge on the Atkins decision. So the first case that really went to look at this was the Penry case. And so in the Penry case, John Paul Henry was convicted of the rape and stabbing of a 22-year-old female who happened to be the sister of a Washington Redskins player. Penry was released from prison only 3 months prior to serving 2 years of a 5-year sentence for rape. He then forced his way into Carpenter, who was the original person that he raped, her home and held a pocket knife to her throat. And while struggling, Carpenter managed to grab a pair of scissors and stab Penry, but he still ended up, he drug her from the bedroom, raped, stabbed her, and ended up killing her. And so when this case was held, it was found, so Penry was found to have an intellectual disability. So he had IQ tests and different evaluations from various psychologists that showed that he did have an intellectual disability. And so this was the first case that was brought up that said, should we execute individuals with intellectual disability? This case and the Atkins case were never arguing that he didn't do those things, but it was saying, was that an appropriate punishment for this population? And I think it's important just to take a pause here, and I think it can be easy for your own, obviously, views on the death penalty, whether you're for or against, to kind of come in to this. But I think it's important that when you're looking at the Atkins case specifically, to understand how sometimes your viewpoints on the death penalty in general can kind of get in there and affect how you might feel or think. And throughout all of this, and even your prompt for your discussion post based on this is kind of asked what this decision ultimately does for individuals with intellectual disability. Does it help society value or not value them a little bit more? So I think it's important, before we get into some more specifics, to pause and think about your own views on it, and not that either are right or wrong, but to see how that might impact how you feel about the Atkins decision. So in the Penry case, again, they were not arguing, and in Atkins cases, they're never arguing that somebody shouldn't be punished or that they didn't commit the crime, but rather, should they execute an individual with an intellectual disability? Should we be able to use capital punishment? And in this case, in 1989, they ruled against not executing an individual with intellectual disabilities. Found it was not cruel and unusual punishment under the Eighth Amendment. This is important in understanding that the Eighth Amendment and the cruel, which is bans cruel and unusual punishment, is important because that is one of the main basis of rationale for why the Atkins case was ultimately decided. So make sure you pay close attention to that and have a good understanding of that. So the jury was not given adequate consideration of intellectual disability as a mitigating factor in this case. Penry was retried for capital murder and again sentenced to death in 2001, but he was ultimately spared due to Atkins in 2002. So the Atkins case, we're going to go through that. But before we do that, I'm going to actually bring up here. We're going to read the oral, like the opinion announcement, which is what the court laid down as they're like after they heard all the facts and had all the information, why they decided to ban the use of the death penalty for individuals with intellectual disability. I always think it's really helpful to hear directly from the court themselves. I feel like they can explain it better than any of us can. So I'm going to show you guys a couple minutes of just the actual oral opinion from John Paul Stevens on why Atkins was decided.
The opinion of the court number 008452 Atkins against Virginia will be announced by Justice Stevens.
Those mentally retarded persons who meet the law's requirements for criminal responsibility should be tried and punished when they commit crimes. Because of their disabilities in areas of reasoning, judgment, and control of their impulses, however, they do not act with the level of moral culpability that characterizes the most serious adult criminal conduct. Moreover, their impairments can jeopardize the reliability and fairness of capital proceedings against mentally retarded defendants. Presumably for these reasons, in the 13 years since we decided the case of Penry against Linau, the American public, legislators, scholars, and judges have deliberated over the question whether the death penalty should ever be imposed on a mentally retarded criminal. The consensus reflected in those deliberations informs our answer to the question presented by this case, whether such executions are, quote, cruel and unusual punishments, unquote, prohibited by the Eighth Amendment to the federal Constitution. This case comes to us from the Supreme Court of Virginia. The petitioner, Darrell Atkins, was convicted of a particularly brutal crime, a capital murder. At the penalty phase of his trial, an expert witness testified that Atkins is mentally retarded. The expert's conclusion was based on interviews with people who knew Atkins, a review of court and school records, and the administration of a standard intelligence test that indicated that he has an IQ of 59. The jury nevertheless sentenced him to death. On appeal to the Virginia Supreme Court, Atkins argued that he is mentally retarded and therefore the state may not execute him. Relying on our holding in the Penry case, the state court majority, over the dissent of two members of the court, rejected this contention and affirmed the sentence. The two dissenters argued that the imposition of the sentence of death upon a criminal defendant who has the mental age of a child between the ages of 9 and 12 is excessive. Because of the dramatic shift in the state legislative landscape that has occurred in the past 13 years, we granted certiorari to revisit the issue that we first addressed in Penry. We now hold that the Eighth Amendment prohibition against cruel and unusual punishment categorically forbids the execution of the mentally retarded. Our analysis begins with the text of the Eighth Amendment, which succinctly prohibits excessive sanctions. We have read the text of the amendment to prohibit all excessive punishment, as well as cruel and unusual punishments that may or may not be excessive. A claim that punishment is excessive is judged by the evolving standards of decency that mark the progress of a maturing society. This inquiry is informed by objective evidence, most notably by recent legislative enactments. In cases in which a consensus among the states has emerged, our own judgment is brought to bear by asking whether there is reason to disagree with the judgment reached by the citizenry and its legislators. With respect to state legislation, we find that much has changed in the 13 years since we decided Penry. At that time, only two states had specifically addressed the precise issue and forbidden the execution of the mentally retarded. Since then, however, 16 additional states have adopted a ban. In other states, bills have passed at least one house of the legislature. Moreover, in states that allow the execution of the mentally retarded, the practice is not common. Prior cases teach that we should focus our attention on statutes expressly addressing the relevant issue. When we do so, we find, in the words of our opinion in Enman against Florida, that there is unquestionably a consensus in the judgment of the legislatures that have recently addressed the matter. For reasons stated in the opinion filed with the clerk today, we agree with the consensus that has emerged. The number of states that have addressed the issue is less significant than the consistency of their enactments and the direction of the change, given the well-known fact that anti-crime legislation is far more popular than legislation providing protections for persons guilty of violent crimes. The large number of states prohibiting the execution of mentally retarded persons, and the complete absence of states passing legislation reinstating the power to conduct such executions, provides powerful evidence that today our society views mentally retarded offenders as categorically less culpable than the average criminal. Despite repeated dissents from some members of the court, our jurisprudence has consistently confined the imposition of the death penalty to a narrow category of the most culpable offenders. The mental deficiencies that by definition characterize the mentally retarded categorically remove them from this group. Executing the mentally retarded does not measurably further the goal of deterrence. Moreover, there is reason to believe that the reduced capacity of mentally retarded offenders means that they face a special risk of wrongful execution. In sum, construing and applying the Eighth Amendment in light of our evolving standards of decency, we hold that the Constitution places a substantive restriction on the state's power to take the life of a mentally retarded offender. As we did in Ford against Wainwright, with respect to the execution of the insane, we leave to the states the task of developing appropriate procedures to enforce this substantive constitutional restriction.
All right. It is longer, and so if you guys would like to listen to the rest of it at your leisure, you're certainly welcome to do that. I personally enjoy listening to those things. Understand they can be a little bit dry, but again, I think it's best to hear it from the horse's mouth. Important to point out before I get into some more details, specifically of the case surrounding Daryl Atkins, I do want to point out in the end it highlights that the Wainwright case, which says that we can't execute people that are found to be insane, quote unquote, this case is completely different. So the Atkins case only specifically protects individuals that have an intellectual disability. And the not guilty by reason of insanity plea is completely separate from this. So just want to make sure that that's really clear. So just some background on the case. We heard why it was decided, and I'll get into some of those specific facts a little more explicitly for you guys for your reference. But so what had happened was Daryl Atkins was with another individual. He was 18 at the time. And they walked to a nearby convenience store and where they kind of kidnapped or abducted a male who was in the Air Force, and they took his money, but then they also brought him to a nearby ATM and forced him to withdraw more money. They ended up driving him to an isolated location after that and shot him 8 times, killing him. There is ATM footage, camera footage that shows that the 2 individuals did take him, made him withdraw money. And there's also forensic evidence that was found in the person that was killed vehicle. So Atkins and the other suspect were quickly tracked down and arrested. While they were in custody, each man claimed that the other person had pulled the trigger. Atkins' versions of events, however, were found to contain a number of inconsistencies. So doubts concerning Atkins' testimony at the time of his initial trial were strengthened when a cellmate claimed that Atkins had confessed to him that he had shot Nesbitt, who was the person that they killed. A deal of life imprisonment was negotiated with the other person for his full testimony against Atkins. The jury decided that Jones, the other person's version of events, were more coherent and credible, and convicted Atkins and sentenced him to death. So again, it's important to have a little bit of background because whether or not he was the one, he was convicted to be the convicted to be the one that did pull the trigger and kill them. But just thinking about some of those pieces, details, I think are important to consider, especially what we know about individuals with intellectual disability and the vulnerabilities they face in being, more susceptible to committing crimes and confessing and those types of things. Whether or not that was true in this case, we're not sure. But in general, the details of the crime, as you guys will read through those articles, are not allowed, the articles that are assigned for you guys, are not allowed to be taken into account when deciding whether or not the Atkins decision can be applied. They can certainly be used at trial when someone is found to be guilty or not, but they're not supposed to be used when determining whether or not the Atkins decision can be applied, so the person can't be executed. So it's kind of two parts there. So I want to make sure you guys are clear on the fact that there's a trial that's held, whether or not someone is guilty, and then if they're deemed to have an intellectual disability, capital punishment cannot be, or the death penalty cannot be imposed. Now, it's not as easy as that, as we will see in part 2. And as you guys read through all those articles, how difficult it can actually be to apply the Atkins decision and prove that somebody has an intellectual disability. And this is where, when we talked especially about in the first 2 modules about assessment and the use of clinical judgment and retrospective diagnoses, if no one's ever had a diagnosis, this is where this becomes really, really critical. So we'll get a little more into that, but I just want you guys to know that the details of the crime, I think, are important to hear because something horrible absolutely did happen. But when deciding Atkins cases, it's not supposed to be taken into account. However, when you have the details, and especially with the knowledge you guys have now about this population, details of the crime, I think, can give you some insight maybe into some cognitive or adaptive behavior strengths or deficits. So I think that's kind of just some food for thought for you guys, and as to maybe they should or shouldn't be taken into account when the decision, Atkins decision, is being applied. So on June 20th, 2002, the Supreme Court issued its landmark ruling that ending the execution of those with intellectual disability. So in the Atkins case, the court held that it's a violation of the 8th Amendment ban on cruel and unusual punishments to execute death row inmates with quote-unquote mental retardation. The Supreme Court decision was 6-3 and ruled that executions of mentally retarded criminals are cruel and unusual punishments and prohibited by the 8th Amendment, as you guys heard in the opinion that was laid out. The court cited the growing number of states prohibiting the execution of persons with mental retardation as a reflection of society's view that offenders considered to have mental retardation are categorically less culpable than the average criminal. So think about that. What does that mean? And also think about, again, I'm going to consistently kind of ask this question, and it's a big part of your discussion post prompt from me, is how does that rationale help or maybe hinder society's perception of this population? The court also reasoned that it was not persuaded by the execution of mentally retarded criminals would measurably advance the deterrent of the retributive purpose of the death penalty. So, and as you kind of heard in there, the court described how a national consensus that the intellectually disabled should not be executed had emerged, and that wasn't there in the Penry case initially. And so this is just a little bit about the history of that. So in 1986, Georgia was the first state to outlaw execution of those with intellectual disability. Congress, along with 21 other states, joined in outlawing execution of individuals with intellectual disability, again, at a state level. So while there are 50 states, like I pointed out in that map before, 19 don't allow the death penalty altogether, so under any circumstances, making 21 out of 31 a clear majority of death penalty states. So in light of the consistency of direction of change, as you guys heard, toward a prohibition of the execution of the intellectually disabled and the relative rarity of such executions at states that still do allow it, the court proclaimed that a national consensus had developed. So that was one of the rationales. And now we're going to get into a little more specifically some of those other pieces. And again, I really want to draw your attention to these because I think it's important, again, to take pause with each of these and think about what they really mean and what they mean for our population. Are they true? Are they not true? Do they perpetuate maybe some stereotypes? Are they still true? Is it still important? again, I'm not advocating for right or wrong in any way, but I think it's important to be reflective when you're thinking about some of their rationales. So the relationship between mental retardation and the punitive purposes served by the death penalty justifies the conclusion that executing those with intellectual disability is cruel and unusual punishment that the 8th Amendment should forbid. So make sure you guys know that. So this is, again, kind of now all the reasons why. So I'll know they can know the difference between right and wrong. These deficiencies mean that they have a lesser ability to learn from experience, engage in logical reasoning, and understand the reactions of others. So inflicting the death penalty on individuals with intellectual disability is less likely to deter other individuals with intellectual disability from committing crimes. As for retribution, as far as that's concerned, society's interest in seeing that criminals get their just desserts means that the death penalty must be confined to the most serious of murders, not just the average murder. And the goal of retribution is not served by imposing the death penalty on a group of people who have significantly less capacity to understand why they're being executed. So because those with intellectual disability are not able to communicate with the quote-unquote same sophistication as the average offender, there is a greater likelihood that the deficiency in communicative ability will be interpreted by juries as a lack of remorse for their clients. So because, the understanding is they can't communicate in the same ways that an average person with average intelligence can, they may not be looked at as remorseful by juries. Additionally, it was noted that they typically make poor witnesses, or they're more likely to be prone to suggestion and willing to confess in order to placate or please their questioner. As such, there is a greater risk that the jury may impose the death penalty despite the existence of evidence that suggests that a lesser penalty should be imposed. So in other words, again, in general, unless it can be shown that executing individuals with intellectual disability serves as a mean of deterrence, there's no purpose. And additionally, this also gives some rationale and some information about individuals with intellectual disability not being able to understand the difference between right or wrong, being more likely to confess, and all of those types of things. So it's important to kind of understand the court's rationale for why they decided this case. I also think a good example that highlights this, which is a bit of a side, but if any of you guys have watched Making a Murderer on Netflix, if you haven't, I recommend it. This stuff, again, Atkins specifically doesn't come up, but one of the individuals, it doesn't explicitly say they have an intellectual disability, but based on the information, pretty certain that he does, and kind of look at his experience with the justice system. Again, it's not directly related, but whenever I kind of think about this stuff and just difficulties individuals with intellectual disability and cognitive delays, the difficulties they might experience with the criminal justice system and being able to understand the process, I think it highlights some of that. So thanks for your attention here in part one. In part two, we're going to talk about just some different points and counterpoints to think about with Atkins. We'll look at a riveting C-SPAN video. C-SPAN is always so interesting, but a clip that was from actually when this was decided, and different callers kind of calling in and talking about how they felt about it. We're not going to watch the whole thing, but just pieces, again, just to kind of take the temperature of how the country and society was kind of feeling at that time. And then we'll talk about some later developments in Atkins, some statutes passed after, and then some issues with assessment, and then a recent case. So thanks for your attention, and we'll see you guys in part two.